Good afternoon, and welcome to another edition of Facebook Live coming from Chisholm, and Kilpatrick. My name is Christian McTarnigan. I'm an attorney that practices on the court practice here, and with me today to talk about how to win your VA claim is Jordan Code and Lindy Nash, who are also both attorneys at the firm. So this is kind of a broad strokes, 10,000 foot view kind of conversation that we're going to be having here today. So let's start super basic with you, Jordan. What is VA compensation and how does it differ from other things that the VA does?
Sure. So VA compensation is basically a monthly benefit, monthly check for disabilities or injuries that are incurred in or related to service. So it's different from other VA benefits like healthcare or like vocational rehab, for example, which provide a service as opposed to a monthly compensation check for the impairment in earning capacity that might come up from a veteran's disability.
So one of the first steps in getting that compensation that you were talking about is getting service connected for that disability. So Lindy, what does it mean to be service connected?
Sure. So service connection is just something that you need to prove basically and be granted service connection. And service connection just means that your disease or disability or injury is causally related to service. So it had to be something from your time in service that occurred in order to be compensated for that injury. So
there are a few elements or a few things that a veteran needs to prove. In order to the VA to grant you service connection or to find that you're entitled to service connection. So you just talked a little bit about in-service injury, which is something that happened to you in service. It doesn't need to be something that happened to you during wartime. It doesn't need to be something that happened to you when you're fighting. It can be anything that happened to you during your time in service. So there are two other elements though. So why don't you talk about elements 2 and 3, Jordan?
Sure. So you need a current disability, which means, right now as you're filing the claim, you have a disability or an injury that's causing you some impairment in your life. And then you also need a medical nexus between that current disability and whatever it was that occurred in service. So a doctor or someone that's medically qualified to connect the two.
So we have an in-service incident, we have a current disability, and then connecting those two, we're going to have a favorable nexus opinion or a medical expert or a qualified expert saying that, yes, what happened to you in service is what's causing this current disability. So I think that a lot of our veteran viewers and a lot of veterans in general are interested in sort of what standard, right? Because nexus is really, really important. As are, of course, all the other elements, but, practicing at court, a lot of times my clients are involved in cases where the nexus isn't there. So either a VA examiner or the appropriate medical personnel says, no, Mr. or Mrs. Veteran, that disability or what happened to you in service didn't cause this disability. So what standard should these examiners be using?
Yeah, so the important terminology, if you will, is the more likely than not standard. So it's kind of 50% more likely that that injury or disability or disorder is due to that event in service. And I think it's also important to note that although we're talking about these 3 elements, that is kind of what we call direct service connection. Mm-hmm. And there are different ways to get service connected, but I'd say direct is probably the most popular and what everyone would think of and kind of go to first. So this is only one way. There are some other more nuanced ways of service connection.
Sure, absolutely. That's a fantastic point. So now that we sort of have an understanding of the 3 elements you need for service connection, let's take a step back. Lindy, do you want to talk about filing a claim for service connection at the VA?
Yep, definitely. So obviously to even get to service connection, you have to file that first claim with the VA. And so to do that, you would file what's known as a 526EZ form. And actually, the 526EZ is the only form that's accepted right now. We used to have an option. It was the 526 long form and then a 526B and the 526EZ. There were a couple different ways. But now that we're in appeals reform, and I'll talk about that a little bit later, but appeals reform officially started on February 19th, 2019. So now that we're in appeals reform, the 526EZ is the only option for a formal claim. So once you fill that out, you can bring it in person to your local VA office, your local VA regional office. You can also mail it, snail mail or fax it to what's known as the EIC, the Evidence Intake Center. That is in Janesville, Wisconsin, I believe. And VA just did that a couple of years ago, and they basically want everyone to send everything there, so they will upload it all to their corporate online system. So that is how you would file that kind of claim, either in person at the VA, your local office, or you can send it to the EIC, the Evidence Intake Center, via mail or fax.
So a quick follow-up question to that. I know I'm a pretty fastidious person. These claims are important. What do I do as a veteran once I file a claim to make sure that everything's going smoothly and that the EIC or whomever actually received that document?
Yeah, that's a great point. So something that everyone should keep in mind is that there are ways to follow up with the VA to make sure that they received your claim and that it is uploaded into the system. And that also goes for appeals and evidence and whatever else you're sending to the VA. And so we have access to what's called VBMS, which is their corporate online system. So you can feel free to call VA and the regional office and just say, hey, I dropped this claim off with you last week, or I sent this into the EIC a couple weeks ago. I just want to make sure that it's uploaded and pending. The VA uses this end product system, and so they'll assign a EP or end product to every pending claim or appeal just to make sure that they don't lose track of it. So that is one way and an important thing to do to make sure that VA is on it and they have everything and it's pending and good to go.
Great. So Jordan, now we have a claim. We followed up. We know that VA has it. What happens next? What are they going to do with that claim?
So the first thing that they're going to do is most likely look to develop the claim. So a veteran service representative is going to look at the claim and sort of see what elements may be already met just by whatever the veteran has already sent in, or what might be missing, and they might do some what's called evidentiary development. So that could include gathering VA treatment records, service records, maybe getting a C&P examination for the veteran if they determine that's warranted. All
right. So you talked about service records, right? You talked about compensation and pension examinations. Just generally, to either of you, whose responsibility is it to get the service records, for instance? Does the veteran need to hold on to their service records? Should they have? Do they need to do anything like that? Because I know I have a lot of clients that will call me and say, I have all my service records. Luckily, most of them are in there when I do it. But what about a veteran that's just starting out in their claim?
Yeah, so it is beneficial if you have those things, ready at your fingertips. If you'd like to submit that with your claim, that's always super helpful. And if you have obviously private medical records, you want to submit those, that is great as well. However, the VA does have a duty to assist. So that means they have a duty to assist the veteran in developing their claim. So if you, I guess technically you don't really have to submit anything with your claim, although I think it's unwise. But you can let VA kind of take the wheel and get whatever service records you're missing or opinion you may need. However, I would always suggest submitting anything that you think supports your claim.
And you had mentioned compensation and pension examinations. I know that we've done Facebook Lives on this before, but just in a nutshell, what is a C&P examination?
So it's basically an exam that a medical professional at the VA performs of the veteran, and it covers both the severity of the condition, but in the service connection context should cover what the current disability is and whether there's a relation to service. And I know we've done other videos on it, but generally the examiner kind of watches the veteran the moment they walk into the office, and then they record into the report both their observations and things that the veteran is saying during the exam.
Sure. And this is definitely talked about more broadly in our posts about it and in our Facebook Live about it, but be honest with your C&P examiners. Explain to them, don't be stoic that day, don't show how strong you are, that the purpose of that examination is to sort of see in the service connection context, whether your disability is related to service, or if you get into an increased rating, how severe your disability is at that time. So service treatment records, it seems like the VA would be responsible for getting. The C&P exams are something that under the law, when certain elements are met, VA is required to get. So what type of evidence is the veteran responsible for? I heard you mention private treatment records, private examiner statements, and things like that, Lindy? Would that be something the veteran should submit or required to submit?
Yeah, they're definitely not required to submit anything, but it is in their best interest to do so, I would say. So if you're, seeking service connection for a back disability and your, treating physician is willing to write you an opinion saying, yes, this back disability is due to your time in service, or is more likely than not due to your time in service, then that is great. And I very much suggest that you submit that. Okay. Along the same lines, if you have any lay statements that you'd like to submit yourself discussing the severity of your condition, or a buddy statement from someone you were in service with, or maybe a family member who can talk about how you were when you returned home from service or what you experience on a daily basis, those lay statements are super helpful as well.
And that's a good description of what kinds of evidence you can use. You can write a statement yourself. You can get a statement from a friend, a fellow service member, and things like that, in addition to these other types of evidence. So we have a question from Michael, and I'm going to direct this question to you, Lindy. What changed with the duty to assist with this new appeals reform? Thank you for the question, Michael.
Yeah, so I would say the biggest change is that, and I was going to talk about this a little bit later, but I can talk about it now. In appeals reform, you now have a different way of appealing a decision that you don't like. So now there's 3 different lanes. You can do the supplemental claim lane, the higher level review, or the board lane. And then there's also more choices off of the board lane. But for this question, the duty to assist now only applies in the supplemental claim lane. And supplemental claim means that you are submitting new and relevant evidence. So if you choose higher level review, you cannot submit any new evidence. The record is closed to what's already been submitted. And the board lane, there's some other options there as well. But in that supplemental claim lane, you can submit new and relevant evidence, but the duty to assist only applies in that supplemental claim lane. I hope that answers the question. Right.
So before we move on to away from the evidence portion of this conversation, I think that a lot of veterans would be interested in knowing, are there certain types of claims that require certain types of evidence, or can you basically treat all of your claims differently? And like we have alluded to, VA should be letting you know what you need to be doing to make your claim successful. But can you think of any examples, either of you, of something that might be a little different than just run-of-the-mill, for lack of a better way to describe it?
Sure. So like a claim for PTSD, for example, might require more evidence to verify the stressor that caused the PTSD. In certain circumstances, that might be the case. The same could also be true for a claim based on herbicide exposure. Okay. There might need to be additional or different evidence that establishes where the veteran served in order to establish whether he or she was exposed.
I think those are 2 great examples. And it also just a reminder, make sure you're reading what VA is sending you. Sometimes they're incredibly long documents. Sometimes they are incredibly complicated documents. But in most of them, and there should be in all of them, they explain to you what you need outside of all of what we call boilerplate, just listing all the law and numbers and everything like that. So make sure you're reading all of that to understand what you need to give VA for them to find in your favor. So the process starts with filing a claim, getting all your evidence in. Along the way, what pitfalls do you think people should be wary of, Jordan, when they're going into filing a claim?
So I think we kind of alluded to it, but definitely being aware of the status of the claim, reading everything that VA sends to you. It can be, it might seem like a document that's maybe not that important, but read it thoroughly. If you don't understand it, ask someone for help to sort of figure out what it is that they're saying, because you don't want to miss an opportunity to either appeal something or, a lot of times I've seen in our court practice, a veteran might miss a CNP examination. Either they missed it, couldn't make it that day for some reason, or weren't available. And if they don't say anything, that can be detrimental to the claim. So it's okay if you can't make it. If VA schedules the exam, just let them know and try to get it rescheduled and make sure that that's in the record. That's definitely one that I've noticed.
Okay. Any pitfalls that you can think of, Lindy?
I was going to say that I wouldn't wait to file something. So sometimes, you have you want to file a claim for your knees, service connection for your knees, but you don't really have everything you need just yet. And so you're thinking, oh, I shouldn't file the claim until I have everything that I need. Well, VA has what's known as an intent to file, so you can submit your intent to file to reserve your effective date. Although under appeals reform, I'm not sure if that is fully accepted anymore, but we're still doing it. So I would suggest doing it to preserve your effective date. So you don't have to submit everything at the same time, although I do suggest getting everything together so that it's in a nice package for VA and that they don't have to go looking for anything and they can just look at everything you've submitted and hopefully grant your claim.
So before we keep going with pitfalls, because I think there's a few more things, we want to address there, I want to ask this question for Jennifer. Thanks for the question, Jennifer. How helpful is a nexus letter? So we sort of had alluded to before, or maybe even more than alluded to, discussed how nexus is an element of service connection. Lindy, you practice in our agency practice. How helpful would a nexus letter be for a veteran who is trying to get service connected?
Very helpful. That is great. And if you are treating with a private physician, if they can write you a nexus opinion letter, that is awesome. A lot of the clients that I work with, we are missing that nexus component. And for some reason, maybe they don't treat regularly or something along those lines. And so we would often go and try to get our own opinion, and that can, take time and it can be costly. So if you have your own, or if your private physician is willing to give you one, that is awesome. And also, we were talking about this before, but VA relies so heavily on their own C&P exams. They will frequently give our opinions or the veteran's opinion no probative value, but give their exam a ton of value. So if you can kind of bypass that and give your own opinion that's favorable, then I think that's awesome.
So we've been talking a little bit about ratings, and I want to take a step back here and just explain for I think that many people would know, but what is a rating?
So the rating is the percentage assignment that's assigned to your disability after it's service connected. And that correlates to the amount of money that is then released to you every month for compensation. And it's based primarily off from the impairment in earning capacity that your disability causes. But each disability or injury or disease has different ratings or different criteria in the rating schedule that kind of correlate to that. And so, then a knee disability is rated differently from PTSD, obviously, or even a back disability. And the ratings kind of go through what a veteran needs to have, sort of what the disability picture should look like.
And obviously, a veteran would want the highest rating possible. So sort of leading back into our pitfalls discussion, one of the best things you can do is to advocate for yourself, I think. Tell the VA what your symptoms are. Tell the VA how it affects your life. Ask VA for a particular rating. Don't unnecessarily limit yourself because you might not know what rating you're entitled to, but be honest, be truthful, and if VA isn't getting the message, just continue to let them know, and continue to follow up to make sure that they're processing the claim, they're working on the claim, and that they've received your statement about how it affects your life. Because like Jordan said, the ratings are a proxy for occupational impairment, but a lot of the rating criteria for post-traumatic stress disorder, for instance, really take how it affects your day-to-day life into consideration a great deal.
Yeah, definitely.
So what if, so you're right, granted service connection, then you get a decision that gives you a 10% rating, or let's say a 30% rating for post-traumatic stress disorder. You don't like the decision. What can you do about it, Jordan?
So you can appeal it, and the ways to appeal it have sort of changed now. Lindy kind of talked about that a little bit earlier with the AMA and the appeals modernization. So you can disagree with it and appeal it, and then VA is supposed to take another look at it, and depending on which lane you choose, you can possibly submit new evidence or have someone else take a look at it.
So in the legacy system, there was you disagree with the NOD, right? That's what we were talking about. And then, Lindy, do you want to pick up on maybe just a little bit more specificity in the appeals lanes in appeals modernization. We do have an entire Facebook Live on this, but just touching on it briefly because it's incredibly relevant.
Right.
Give us the elevator pitch.
Sure. So basically, like I said before, February 19th, 2019 was the day that appeals reform began. So it was signed into law a couple years ago, but it didn't start until February 19th, 2019. So if you get one of those initial rating decisions with a date after that, so say you get one today or yesterday, you're now in the new system. So you are not under the traditional appeals system that we're working with before. You're now in appeals reform. So now you have three options, which I alluded to before. The first one is higher level review. And so that means you basically want, a specialist at the RO who has a little bit more experience than the person who looked at it originally to review your decision de novo. So to take a first look at it. Again, you cannot submit any new evidence. It's based on what is already in the record. So that's higher level review. You can do a supplemental claim lane, which I also mentioned before, and that is the lane where you can submit new and relevant evidence. So if you all of a sudden got that private physician opinion, you want to submit that, great. If you want to submit a statement or medical literature or something that's not in the record already, you would opt into that supplemental claim lane. Your third option is the board lane. However, there's three options within the board lane. So follow me here. At the board lane, the first option is the hearing lane. So if you'd like to have a hearing, you can opt into that. The second one would be the direct lane. So similar to higher level review, except you're at the board. So there's no new evidence and they are just looking at what is already in the record. However, you're at the board. And then the last one is the evidence docket. And that means that you can submit new and relevant evidence again to the board. However, it's different from a supplemental claim because you're at the board. So 3 lanes at the board, 3 lanes in general. We have a lot of visuals in our other presentations, so feel free to take a look at those.
So everyone understands appeals reform.
Right, yeah,
right?
it's very clear. It's very clear.
And we have some other information on that forthcoming, or so I've been told.
Yes.
We have a question from Patricia, and it's a great one. If you get approved for herbicide exposure, so the VA concedes that you're exposed to herbicides, but the illness is not a presumptive illness, but you have a nexus letter, how does that work? So I've been asking all of you guys the question. So I'll take a crack at this one, and then please jump in with your thoughts. So getting service connected for a disability due to Agent Orange on a presumptive basis is only one way to do it. So let's say you were exposed to herbicides and you had a presumptive disability. That's it. However, there's case law that says that that's not the only way to do it, and that's not where the VA can stop. So what the VA would have to do is they would have to determine whether, even though you don't have a presumptive condition, whether that condition was caused by your exposure, your conceded exposure to herbicides. And a nexus letter can help with that because it goes right back, this brings us full circle, which is great, to direct service connection, what we've been talking about. So where we started the conversation is sort of where we're ending up now, right? You would have the in-service incident, you would have nexus, and then you would have the current disability. And so that's how sort of that would all work when it's not a presumptive condition under the regulations or under VA law.
Yeah. Definitely.
Does that work?
Yeah.
All right.
Yeah. If you have a private opinion saying that your condition, even though it's not presumptive, it's not on the list, then that's great. And I would submit that.
I was actually working on a case that involved that very issue right before I came in here. So I think that at this point, we're sort of on final thoughts. We've talked about a lot today. And we were talking about things generally. If there are any more specific questions or specific issues, please take a look at our page to see if there's any more Facebook Live or other materials that might be able to help answer your questions that we didn't get into today. But any final thoughts before we wish our audience well?
I guess I would just say this is sort of another maybe pitfall that we didn't really get into, but just being as clear as you can when you're filing an initial claim about what happened, let's say it's a claim for service connection, what happened to you in service, what happened to you after service, and where you're at now, and sort of how that has progressed. If you didn't seek treatment for a little bit of time after service, and there's a reason for that, maybe, your condition was easily treated with over-the-counter medication or something like that, you can explain all of that to VA, and that might end up being helpful to you down the road. So just being clear and honest as early on, I think, is really helpful.
Yeah. Definitely. I would say, like Christian said earlier, read everything as thoroughly as you can. The deadlines are real. And it is really unfortunate sometimes when we're working with our clients and we see that, they originally filed a claim in 2011 and they appealed and then they stopped appealing. And unfortunately that claim stream has died, for lack of a better word. And so we can't get it back to 2011. So I would just be really cognizant of your due dates and deadlines, and, keep something on appeal if you believe in it and if you think you have evidence to support it. VA makes mistakes all the time. So, believe in yourself and keep appealing if you think it's not right.
Please update your address with the VA. That's something I had something else I was going to say as a final thought, but it sort of underlies all of this. If they don't know where to send it to and they send it to the wrong place and you miss an appeal deadline and you didn't let them know, you can run into some issues with your claim. So don't assume that they know where you have moved. Make sure to update VA about where you are so they can send those notices to the right place and you don't miss any deadlines.
Yeah. Definitely. And we touched on this, one more thing. We touched on this before, but I think it's really important. At those C&P exams, be so honest.
Yep.
Do not hide the ball. Now is not the time to be tough and, make them think it's not as big of a deal as it is. Be honest with them. Tell them what you're experiencing. Be honest, of course, but just know that they really heavily rely on those exams. So be really honest with them about what you're going through. And I think that's a good way to go.
Well, thanks, guys. Well, thank you for tuning in. This is Christian McTarnigan, Jordan Code, and Lindy Nash at Chisholm, and Kilpatrick. And thanks.